Peace and love, family. It's your brother Isaiah again with another one for the conscious brothers, all the conscious sisters in the conscious community to keep in the struggle because we know it's through the struggle that we grow. Also, I'd like to say that it is, in fact, slow process for progress and that the race is never to those who are swift. It's always to those who remain dutiful. So make sure you stay in this fight for the long. And y'all know I never offer any legal advice. I'm not a legal counsel. I'm not an attorney. I wear no titles outside of being your brother. And I just want to offer to you education and information about my walks and travels throughout my journey called life. And I like to extend these honors to you because when you're honoring man and you're honoring woman, you're honoring yourself. And I also like to give adoration to the Most High. I like to call him Allah, who is the hidden temple of my life, and extend that same love, courtesy, and acknowledgement to all of his messengers and prophets. And I like to say peace to all of you, beloved brothers, sisters, and grand rising to all of God's chosen people. How's everyone doing today? Myself, I'm blessed. I'm taking everything as usual in step stages, in degrees, and I'm constantly unfolding in the womb of these two different worlds that we live in, one lawful, one legal. So I'm gonna go into some things today. I got a couple of guests on from my membership that will be participating in this, maybe asking questions throughout periodically, certain things that I might be discussing. But today I'm going to share a little bit of information to bring home about transfers to help you understand consideration and what's not happening and what's not taking place and where the violations are at, so you can identify uh where your problems are coming in at with your contract. So I'm gonna share my screen real quick. And I'm starting off in 31 USC 1501, documentary evidence requirements for government obligations. Now, all obligations are obligations of the government. And the reason why you need to know that is because if it's currency, then it's a government obligation. If you dealing in currency, if you apply for a loan and currency was extended to you in the form of a debt, right? Then that's a government obligation because you didn't receive gold and silver for your loan. So if you didn't receive any gold, if you didn't receive any silver when you apply for a loan, you receive some other form of currency, then that's a government obligation because the government is the one who approves fiat currency to be issued and accepted as value in exchange amongst parties. So anytime you receive fiat as a loan, then you got to understand you're dealing with something due to the United States. Now, let's read this. Now it says, an amount shall be recorded as an obligation of the United States government only when it's supported by documentary evidence of, number one, a binding agreement between an agency and another person, including an agency that is. So if there's an agreement between an agency, right, and another person, including the agency that is in writing in a way and form and for the purposes authorized by law, and B, executed before the end of the period of the availability for the obligation of the appropriation or funds used for specific goods to be delivered, real property to be brought or leased, or work or services to be provided. So what it's saying that anytime an obligation is recorded and it's evidence that it's an agency relationship that's being recorded, then they have to record that obligation of that agency against the United States, because all agencies are obligations of the United States. as long as it's in some form of writing and it's authorized by law, and it's being executed as proof of the agency before the actual due date, before the goods become deliverable. You see what I'm saying? It says, then it goes into two, a loan agreement showing the amounts and the terms of repayment. So if there's an agency relationship between you and a legal person, you and an LLC, you or something like that, and it's in writing, and you can show you got a loan agreement in the name of the agency, you are an officer who undertook that agency's obligation, and you can prove, right? The United States gives full faith and credit, right? It says a loan agreement showing the amounts and the terms of repayment in order required by law to be placed with an agency, right? An order issued under a law authorizing purchases without advertising. It says when necessary because of the public extinguishing for perishable sustenance supplies or with specific monetary limits, a grant or a subsidy payable from appropriations made from for payment or contributions to amounts required to be paid in specific amounts fixed by law or under formula prescribed by law, and then B is under an agreement authorized by law, or C, under plans approved consistent with and authorized by law. So like when you like deal with like companies like T-Mobile, they always have like plans. That's how they identify their agreements. So any authorized plan with a person in the agency that's showing that you've been approved for, amounts and stuff like that. All these right here, they supposed to, everything is recorded against the United States. So it's actually not your obligation. Every month when they send you a bill, they're not asking you to pay. Any obligation that they bring up is an obligation against the United States. All right. So let me show you. I'm gonna have to move around a little bit, but I'm gonna show you. Let me finish this up. So when you get employment or services or persons or expenses or travel under law, services provided by public utilities, all that's supposed to be recorded as a United States obligation. Other legal liabilities of the government against and available appropriation of funds. So appropriation of funds is when you get approved for a loan and they issue a mortgage. That's an appropriation of funds. And the government is responsible for all. I'm telling you, they're responsible for it. And when these people are billing you, the reason why it's a violation of your rights is because they know that this is a United States obligation, but they issuing it to you. And you're accepting the United States obligation without rejection and demanding that it be charged to the United States. See what I'm saying? Because every amount shall be recorded as an obligation of the United States. Now, let me go somewhere else real quick, see if I can find something real fast. I'm a navigator. Y'all know I've been navigating these waters. I've been navigating these waters. I didn't even know I was in the water, but I didn't even know I was a navigator. Hold on. Go back. So United States Code concerning a creditor's rights to record an obligation due against the United States and bill a debtor for payment. Or
According to Cornell.edu, no debt of any kind shall be entitled to priority under any law of the United States or any state, territory, or possession thereof, or the District of Columbia, solely by reason of becoming a debt due or owing to the United States as a result of its acquisition by the alien property custodian.
So it's really, you really don't owe no debts, right? But I'm trying to find a specific place in the code and see. United States Code concerning the creditor's rights to issue a demand for payment to the debtor anytime a United States obligation arises.
According to Cornell.edu, debt claims shall be paid in the following order of priority: wage and salary claims, not to exceed $600.
All right, I gotta find it. It's in the code, right? Let me see if I can find it. It deals with, if I am mistaken, it's credit card. It's dealing with credit card accounts and the custodian's rights under the credit card account to issue a statement, right? Anytime a obligation for the United States arises. All right, so let's read this. All right, so this is what they filed a proof of claim, right? And in an equity security holder, right, may file a proof of interest. If a creditor does not time, you see, so this is basically telling you these right here are the collections, right? I think this is it. I'm trying to find where it's at so I can show it to you. All right, so this is dealing with like the board of governors, claims arising, acquisition of the contracts. All right, all right, so this is what it is right here. So what I'm trying to do is show the people, like when you get a bill, it's a unpaid obligation, meaning the United States was supposed to pay it and they didn't pay it. So the person who's servicing your account, when they bill you and notify you, they're notifying you of an unpaid balance that's due to the government. And you're supposed to demand payment against the government obligation to pay that obligation, right? Demand for payment prior to initiating administrative offset. Demand for payment will be made as follows. A written demand will be made promptly upon the debtor in the terms which inform the debtor of the consequences of the failure to cooperate. It says the total of 3 progressive strong written demands at no more than 30-day intervals will normally be made unless a response to the first or the second demand indicates that further demands will be futile and the debtor's response does not require rebuttal. In determining the time of demand letter, broadcasting board of governors will give due regard to the need to act promptly so that, as general rule, that referrals to the Department of Justice for litigation where necessary can. So this is where I'm trying to find where it talks about whenever an obligation arises, it's telling the creditors that hold the accounts pretty much that whenever some kind of obligation due to the government arises on any account that they manage, that whenever that obligation is past due to the government to pay, then they must bill the person who is obligated under the account to receive payment. If you are the payee that was selected to receive payment and your payment is past due and the government haven't made payment to your account, the trustee managing your account notifies you, he bills you, he tells you in advance on what's due and when the transfer is able to take place for you to receive your payment. You see what I'm saying? But you got to demand payment. And that's what this is all about, right? I don't know if I'm gonna be able to find it, but I was hoping I can find it, man. I think this is it. I think I may have found it, man. Man, let me see. Unless forbidden by broadcasting. Nah, this is dealing with broadcasting, but it's still dealing with the same stuff. A debtor owes the United States debt. See where it says a debtor owes the United States debt, including amounts of the debt. So what I'm trying to show everybody is that the debt is not yours. It's the United States debt. And you becoming responsible for it because you're not demanding that the United States pay the debt. And the holder entitled to receive payment is trying to notify you. I don't know if I'm gonna be able to find the exact one I'm looking for, but all this right here, it even tell you right here. So, and you go on the definition, said boards meets the Broadcasting Board of Governors, which is the Federal Reserve creditor agency, means the agency to which the debt is owed. Okay, so when you owe a debt, you owe it to a creditor's agency, right? So then it says a debt means an amount owed to the United States. All right. But when the creditor agency that you deal with has a right to receive payment, that amount is an amount due to the United States to pay. You can't pay because you don't have no money to pay with. We only receive currency. So the United States is the only one that can exchange the obligation that they trying to receive dollar for dollar. They can exchange it and pay it lawfully to them. And they're demanding that you demand that the United States pay the debt because you are the one entitled to the payment. So whenever they bill you, that's what they billing you for. Okay. Disposable pay, part of the currency-based pay, special pay, incentive pay, retired pay, retainer, pay or authorized pay remaining after the deduction of any amount required to be withheld by law. So see, it's being withheld. See, by law, they require to withhold it. And it's up to you to demand that it be paid. All right, everything that I'm showing you is the reason I'm trying to show you everything, but I don't know if I'm gonna find exactly what I wanted to show y'all where it actually pretty much gives the breakdown on how whenever they go over account and they see that it's an obligation due, it tells them to basically bill you, but the bill is not actually your obligation, it's the United States obligation, but they send it to you. And then if you don't understand it, you incur the obligation by holding the bill instead of transferring the bill to the United States for payment or providing payment. So let me get back. I'm gonna go back over here. So this is documentary evidence. And if you go to the second page on this right here, it says the balance of an appropriated or fund limited for obligation to determine the period is available only for payment of expenses, property incurred during the period of the availability or to complete contract properly made within that period of availability and obligated consistently. So, however, the appropriation or fund is not available for expenditures for a period beyond the period otherwise authorized by law. So that's that's the reason why a lot of times when you pay, you always, assign the obligation to the United States. And then you make the United States responsible to repay it in lawful money to the holder, stuff like that. But let me go to this other part of the code where I was going to go. All right. Now we're talking about value for transfer of an obligation. All right. So value is given for a transfer or an obligation if in exchange for the transfer of the obligation, property is transferred or an antecedent debt is secured or satisfied. But value does not include an unperformed promise made or otherwise than in the ordinary course of the promisor's business. The promisor, not the promisee, but the promisor. Remember contract law. The promisor is the one who makes the proposal. business to furnish support to the debtor. So why would it say that the promisor is supposed to be furnishing support to the debtor? You see, to the debtor or another person. So somewhere around the line, we got mixed up somewhere. Let's look at what a transfer is. A transfer means every mode, direct or indirect, absolute or conditional, voluntary or involuntary of disposing of or parting with an asset or an interest in an asset. It includes payment of money, release, lease, and the creation of a lien or other encumbrance. So a transfer can do all of that, right? Now, what is a debt? Debt means an amount of money that is owing to the United States on account. So on all these accounts, I hope it's starting to make sense to you because I'm reading it where you can see it. An amount that is owing to the United States on account. So you got money that's due on account, and it's due to the United States of a direct loan or a loan insured or guaranteed. It's guaranteed because it was approved and by the United States. When it's approved, that means the United States will pay it, or an amount that is owing to the United States on account of a fee, a duty, lease, a rent, a service. Wow. A sale of real or personal property, overpayments, fines, assessments, penalties, restitution, damages, interest, tax, bail bond. Wow. Forfeitures, reimbursements, recovery of a cost incurred by the United States. So if I got receipts that I paid at stores or other sources of indebtedness to the United States. Wow. Unbelievable. But that is not owing under the terms of a contract originally entered into by only persons other than United States, and include any amount owing to the United States for the benefit of an Indian tribe or individual Indian, but excludes any amount to which the United States is entitled under 30. Hey, so so when the United States is entitled, right? Let's look this up. I wanna know when they entitled. Let's see what pops up. Oh, so in making a determination of the best interest of the child. So they know that the person that they charging has a child attached to it. Oh my God. You mean to tell me they knew I was the child of that person all the time, but the child might have thought he was the person, but you the child of a person. Oh my God. In a proceeding described in section, the court shall among any other factors. So the only way, hold up, the only way the United States would be entitled is if it was through some sort of court order. So if it ain't through some sort of court order, then they weren't really never entitled to receive any payments. All right, so let me go back. All right, now it says for the purposes of section 3404 and 3307, a person gives a reasonable equivalent value if the person acquires an interest of a debtor. So are you considered a debtor on any account right now? Huh? Did you become obligated some kind of way? Wait a minute, let me read this again. Because, brother, brother Isaiah, I like to read a lot, I want to make sure I'm reading it right. For the purposes of section 3304 and 3307, a person gives reasonable equivalent. Wait a minute, reasonable and equivalent. Don't make me look it up to see what it means. Value if the person acquires an interest. What does it mean to acquire? An interest of the debtor in an asset pursuant to regularly conducted non-conclusive foreclosure sales or execution of a power of sale for the acquisition or the disposition of such interest upon default under a mortgage, deed of trust, or security agreement. Now, of course, you know, I got to see what a security agreement is. It means an agreement that creates or provides for a lien. So that can be any kind of agreement, right? And then we got to look up asset, means the property of a debtor, but does not include a property to the extent it is encumbered by a valid lien. Property to the extent it is generally exempt under non-bankruptcy laws. An interest in real property held in tenancy by the entirety or as part of a community estate. It says, to the extent such interest is not subject to process by the United States holding a claim, only one tenant or co-owner. So as long as so it's saying if the United States got a claim on your asset and it's encumbered, then it's not considered as an asset because the government is damaging it, or they're basically, you know, impeding on your right. They got a lien on your property, and it's really a violation for them to have a lien on your property when they are obligated to pay you for the property. You know what I'm saying? Now it says, for the purposes of the section, I'll say, if value is given or acquires an interest of a debtor pursuant to regularly conducted not okay. Now it says present value means a transfer is made for present value if an exchange between the debtor and the transferee, right, is intended by them to be contemporaneous and is in fact substantially contemporaneous, right? So it's saying that when you enter into an agreement between you and a person that you transferring the property to hold it, when y'all come to a contemporaneous agreement that the same value that they're issuing to you is the same value you're going to pay back to them, then it's considered as a mutual binding agreement. What does this word contemporaneous mean? Let's look this up. So existing or occurring in the same time of period. Now we're going to put legal in front of it. All right. In legal terms, contemporaneous refers to an event or an action happening simultaneously or at the same time as another occurrence. It is commonly used in legal proceedings to establish timing and sequence of events, right? So at the same time, right, that you receive the principal loan, you also receive the interest. And they agree, and you basically making the company agree that at the time of transferring to you the interest, the principal, that at the time that the value is given, because the value that we talking about is the interest that's associated with the document, because you're receiving principal and interest. All right. And the interest is being disclosed as truth in lending, because what's really being loaned is interest. That's what's really being loaned. And they have to give truth in lending and disclosures of the interest, the value that the contract really deals with. And at the time of you receiving the contract and the interest being disclosed to be in your possession, it's a contemporaneous agreement that that if they deliver it to you, that they have to accept a payment of it back to them at the same time when it's available. Do that make sense? It makes a lot of sense. That now we're gonna go to the next phase. Now, a debt arising before the transfer, except as in section 3307, a transfer made or an obligation incurred by the debtor is fraudulent as to a debt to the United States, which arises before the transfer is made or the obligation is incurred. If one, a debtor makes the transfer or incurs the obligation without receiving reasonable equivalent value in exchange for the transfer or the obligation. So wait a minute, this goes back to 1531 USC 1501, where debt should be recorded as an obligation of the United States. So at the time of the transfer, y'all was supposed to record that as something that the United States was supposed to pay in the first place, right? So to record a debt as a debt of mine, something that's due to me, I got to dispute that you incorrect. This is something due to the United States. This is the United States. I have proof that this is the United States. I have a security showing the United States is responsible for this. And that's what a security is. It's currency, and currency is United States obligation. That's why they demand that it be paid in U.S. currency, because they're demanding that you demand payment against the United States. They're not saying that you don't have a right to payment. They're saying you better demand payment to the right person. You see what I'm saying? So that we can settle this account. So, but they just can't give you legal advice. All right. So whenever they create a debt, that's something that's recorded as a United States obligation, and they record that debt as a debt due to you, that's fraudulent. Because you're the payee. You're the one entitled to payment on that debt. And that United States agency has to prove you to receive an amount from the United States. Every loan you have got approved for is been approved for you to receive an amount from the United States for services, for electricity. So now you got to make the United States perform, right? So it's the debtor, if you don't receive anything equivalent to what you gave in exchange, then it is fraudulent. The debtor is insolvent at the time, or the debtor became insolvent as to a result of a transfer or an obligation, meaning you did a transfer or something to a company and you became indebted because of it. Now you got to pay every month. But you gave something of value. The transfer was made to an insider for an antecedent debt. The debtor was insolvent at the time, and the insider had a reason to believe or cause to believe that the debtor was insolvent. Now let's look at this word debtor. Debtor means the person who is liable for the debt or against whom there is a claim for a debt. So the debtor is the person liable for the debt or the person for whom there is a claim for the debt, right? So they're making a claim for a payment of the debt. All right, so a transfer made or an obligation incurred by a debtor is fraudulent as to the United States, whether such debt arises before or after the transfer is made or the obligation is incurred. If the debtor makes the transfer or incurs the obligation with actual intent to hinder, delay, or defraud a creditor, or without receiving a reasonable equivalent value in exchange for the transfer or obligation, if the debtor was engaged or was about to engage in business or a transaction for which the remaining asset of the debtor were unreasonably small in relation to the business or the transaction. So that's why I say it's better for you to do business. Remember, I say it's better because the United States is responsible for all domestic entities. That's why I showed you the form 231, 233 for individual LLC, because they responsible for entities. Because all the entities are their obligations. It's obligation. Remember, corporations were created by government. The government was created by men and men and women were created by God. So when you understand the order of how things work, then as long as you're using a corporation, then you can always assign the corporation's obligations to the government, and the government got to pay those debts because that's a person, right? And when you understand that, you understand what this is talking about and determine actual intent. Under paragraph 1, consideration may be given amongst other factors to whether the transfer of the obligation was to an insider. B, a debtor retained possession or control of the property transferred after the transfer, right? And it says the transfer of the obligation was disclosed or concealed. Before the transfer was made or the obligation was incurred, the debtor had been sued or threatened with a suit. It says the transfer was of substantial all of the debtor's assets. The debtor absconded, the debtor removed or concealed an asset. The value of the consideration received by the debtor was reasonably equivalent to the value of the asset transferred or the amount of the obligation incurred. It says the debtor was insolvent or became insolvent shortly after the transfer was made or the obligation was incurred. The transfer occurred shortly before or after a substantial debt was incurred, and the debtor transferred the essential asset of the business to a lender, right? Who transferred the asset to an insider of the debtor. So basically, whenever you receive an asset or an obligation, you're supposed to transfer that obligation to the United States or to an agency of the United States who can actually charge it against the United States to pay the obligation. It says a transfer is made with respects to an asset that is real property other than a fixture, but including the interest of a seller or a purchaser under a contract for the sale of the asset when the transfer is so far perfected that the good faith purchaser of the asset from the debtor against whom applicable law permits the transfer to be perfected cannot acquire an interest in the asset that is superior to the interest of the transferee. And with respects to an asset that is not real property or that is a fixture, when the transfer is so far to perfect the creditor on a simple contract acquires otherwise than under the subchapter a judicial lien that is superior to the interest of the transfer, right? And the transferee is they talking about is you are the transferee that they transfer to on behalf of the person. If applicable laws permit, the transfer can be perfected as approved in paragraph 1, and the transfer is not so perfected before the commencement of an action or proceeding for relief under the subchapter. The transfer is being made immediately before the commencement of an action or proceeding. So basically, whenever you acquire interest in anything, you're supposed to actually basically you're supposed to be making a claim against the United States for relief. That's why all debts are due to the United States. That's why when you read the redemption manual, it tell you to charge to the United States, make it payable to the United States Treasury, because everything in accordance to the law is a United States obligation in reference to all currency, all accounts. And I showed you that all this stuff is their obligation. They're supposed to be paying for everything, right? And when you go in here and you start reading this, it start talking about fraudulent transfers and how to, that's why everything in the code talks about counterclaim, recoupment, set off, because you're supposed to be counterclaiming. And the reason why I put up 31 USC and went over this is because most people don't know that that they supposed to be recording these debts as obligations of the United States government, right? When it's supported by documentary evidence. So whenever you issue an instrument to them that evidences an obligation of the government, they record it as an obligation due to the government. And if you don't deliver it to the government for payment, and it becomes due as an obligation that the government has to collect, then they'll bill you for the due balance that the government owes. And then they'll proceed to collect on the due balance. But if you deliver the obligation to the government, then the government has to pay the due balance. But if it's never delivered for payment, then the government retains ownership over the due balance and holds an interest over you because you never actually perform. You know, they receive the asset and you never deliver the receipt of your deposit to that company, to the government, to have it paid. So because you're not delivering your rights to payment, then that's what happens. And this right here is basically letting you know that everything that they do is an obligation of the U.S. government. And the U.S. government is the one responsible. So right now I'm gonna open up and let y'all ask any questions and, you know, in reference to anything that I went over. If you got any questions about it, it's the time for questions.
All right. So as far as like somebody coming into this that didn't know what a receipt was, could you explain what a receipt would look like to like a new follower or a new member that's coming in that might not know exactly what you mean by a receipt?
Well, a receipt is it can be a copy of an agreement. It can be a receipt can be a copy of a lease, copy of an installment agreement, copy of any kind of contract is considered as a receipt. A receipt is actually, according to the UCC, means physically taking possession of goods. So when you physically take possession, you have a receipt, and the receipt is proof of ownership. So if you have a right to receive payments that the government is responsible for, the party that gave you the right against the government to receive those payments will have to give you a receipt. A receipt is a copy of the document granting you the rights to payment, which will be the document of title. That document is your ownership to the amounts that's stated in the document, but it has to be delivered to the United States. So that document in itself acts as a receipt. It's considered as the title, but it's also the receipt, which is ownership to your rights to pay.
Right on. So as far as the United States obligation goes, because we are being represented by a United States person, that gives us the right to demand payment on behalf of the person that we're using the commerce. So our receipt would be the document, the title, like you said. But what would make the holder not pay not pay what we're demanding that they pay as far as like the principal balance or the interest? If you get what I'm saying.
Say that one more time.
So once we get the receipt and then we have it in our possession, and say we send in something to say that the holder, that we have the right to get this paid, what's something that might have been done that would not make the holder pay on behalf of the United States person, because it's an obligation of the United States according to 31 USC 1501.
If you don't provide your bond, like your naturalization, your authority to, you know, to receive payment, because the United States is responsible for all legal entities or domestic entities. So if you can prove that you're acting on behalf of a domestic entity created under any United States sub-agency, then they will become responsible to have to pay. You got to prove agency.
Right.
And I wanted to for for those who may not know either, that agency law, and there's differences between agencies. So that's very key in what brother is explaining in proving your agency. It has to be evident and it has to be expressed. So my question I want to ask you in regards to transfers is that when you say that they're entitled, when they're supposed to pay, or we're supposed to be claiming or demanding payment, um, would a form of demand be letting them know that there's a billing error occurring that's encumbering you on their end?
Right. Because you basically letting them know, acknowledging that you have received the obligation of the United States and you have accepted it, and you are the payee who's entitled to receive payment of all the United States obligations, and you're disputing their demand for payment. And basically, you basically endorsing the instrument back to them, payable against the United States. You're making the United States the payee on the instrument, and then you're assigning it to them as a collector. You see what I'm saying?
Right on. Right on. And for those who just for everybody, those who may be watching, I during my studies with Brother Isaiah, he put me on his studies, kind of navigated me and led me into reading a good act that everybody should read regarding demands for payment. And that's the Fair Credit Billing Act. I would suggest everybody go read that. And that's what's another thing I learned by being with Brother Isaiah and his mentorship. It's very good.
All right, so I'm gonna read something real quick. So this right here is dealing with billing errors, and it's talking about a reflection on or with a periodic statement of an extension of credit that is made to the consumer or to a person that has actual or implied or apparent authority to use a consumer credit card or open-end credit plan. So whenever you get approved for a credit card account or a credit plan, you will always receive due amounts on that account. Those amounts are extended credits, right, that are being made to your account. So every month you receive a balance to your account, but they making you pay for the balance rather than crediting you for the balance that's generating to your account. So it's an error. It's a reflection made on a statement of an extension of credit, because they're extending it to you, but they're not acknowledging that it's a credit that they extended. They extending it like it's a due debit, but it's really a due credit. And you have to correct the statement. When you sign a statement, you can put the negative signs by the due dates. You get to modify it. Once you sign it, you can mark it up the way you want it marked, and then endorse it as approved, and then issue it back, because you are the creditor. You get to dictate. It's your account. If you say it's credit, then you make it credit and endorse it, right? So this is how we got to do. Like when you issue the bills back to them, you can't, the bill can't be representing the principal payment on the front. All that got to be changed. When you sign the front of that instrument, you need to modify it. You need to put negative numbers. Like if it got positive amount due, you need to put a negative sign. All the numbers need to be negative. You need to make sure that it reflects credit, and then endorse it. You see what I'm saying? Because you're basically modifying the instrument as a creditor, the instrument, and you endorse it for credit, right? It's a billing error, a reflection on a periodic statement of a creditor's failure to credit properly a payment or other credit issued to the consumer account. See, it's telling you that it's credit. So why you not crediting? A reflection on a periodic statement of a computational or similar error of an accounting nature that is made by a creditor. You're making an error. This is a credit agreement. These should be reflection of due credits, not due debits.
Right.
You see what I'm saying? Not you asking for debits. You should be asking me to make credit payments toward the account. This is a credit agreement. So why doesn't this statement reflect a due credit? It should be reflecting a reduced balance. A reflection on a periodic statement of an extension of credit for which a consumer requests additional clarification, including documentary evidence. The creditor failure to mail or deliver periodic statements to the consumer's last known address, that is, the address was received by the creditor in writing at least 20 days before the billing for which the statement was required. A billing error notice is a written notice from a consumer that is received by the creditor that at the address under the contract as applicable no later than 60 days after the creditors transmitted the first periodic statement that reflects an alleged billing error. See, all of it, even when the banks say that you owe a balance, all that's an error because all that should be reflecting credits, all of it. It says enable the creditor to identify the consumer's name and account number, and to the extent possible, indicate the consumer's belief in the reasonable belief that the billing error exists in the type, date, and amount in error. And then they talk about the resolutions, right? And it tell you all the things they're supposed to do. It says a consumer's rights to withhold the disputed amount, collection activity forbidden. The consumer needs not to pay. Any creditor may not try to collect any portion of any required payment that the consumer believes is related to a disputed amount. So any amount that I dispute, you can't even collect it, bro. I dispute this whole entire debt. I disputed that I owe any amount, that this is a credit, and that you're misrepresenting the nature of our agreement. I dispute all charges. Once you do that, they can't even collect. It's disputed. If a card holder has enrolled in an automatic payment plan offered by a credit card issuer and has agreed to pay the credit card indebtedness by the period deduction from the cardholder's deposit account, the card issuer shall not deduct any part of the disputed amount or related finance or other charges if the billing error notice is received anytime up to 3 business days before the scheduled payment date. So if you issue a billing error, even though you had it set up for them to take, they can't even take a payment, yo. They can't even take a payment. I ain't telling you, I'm proving it to you.
Freeze that for me real quick. Hold on, player.
Need to write that
Already.
down. That's fire right there. So
Yeah, already.
all right, then it says the creditor or its agent shall not directly or indirectly make, threaten, or make any adverse report to any person about the consumer's credit standing, or report any amount or account is delinquent because the consumer's failure to pay the disputed amount or related finance charge or other charges. So you can close, you can tell them I don't want to do business with you no more and just dispute everything, and tell them I dispute everything. You don't have the rights to put it on my credit report or none of that. It's disputed. Acceleration of the debt and restriction of an account forbidden. A creditor shall not accelerate any part of the consumer's indebtedness or restrict or close the consumer account solely because the consumer has exercised in good faith the rights provided by this section.
Right.
A creditor may not subject to the forfeiture penalties under 15 U.S.C. 1666E. And I think this is where it's at, where I was talking about the notice that they got to record against the United States debt for failure to comply with any part of the requirements of this section. Permitted creditors action. A creditor is not forbid it from taking action to collect any undisputed portion of the item or bill, from deducting any disputed part and related finance or other charges. So all these, so let me explain to you in the full detail. All these companies that you're dealing with are acting as debt collectors for the United States. And because you're not disputing them, you thinking that they are the government. They got us all believing that they the government. They got the rights to, we got to charge, we got to pay for services, and when really all our services is supposed to be paid by the government. But because we're not demanding payment, then their little third party holders is acting as debt collectors for the government,
And jamming you up.
right. And because you're not disputing the debts, you're not treating these companies like regular debt collectors and disputing their claims and demanding, saying that it's a United States debt, then
You
they're
hold liability.
liable. You see what I'm saying? That's what's really
Yeah.
going on,
It
right?
say, well, hold on real quick, brother Isaiah. 15 USC 1666E is titled Notification of Credit Card Issuer by Seller of Return of Goods, etc. by obligor, credit for account of obligor. And it's literally one paragraph.
Mm. So, all right, so let me see. So this right here is very powerful, because this is right here is the procedures if a billing error occurred as assessed. If the creditor determines that a billing error occurred as asserted, it shall, within the limits of the time, will correct the billing error, credit the consumer account with any disputed amounts and related finances or other charges as applicable, and mail or deliver a correction notice to the consumer. Procedures if billing error or notice billing error occurred: if, after conducting a reasonable investigation, the creditor determines that no billing error occurred, or that the different billing error occurred from that assertion, the creditor shall, within the time limit in the paragraph C2 of this section, all right, mail or deliver to the consumer an explanation that sets forth the reason for the creditor's belief that a billing error alleged by the consumer is incorrect, whole or in part. Furnish a copy of documentary evidence of the consumer's indebtedness, which is fraud, because the indebtedness will always be against who, y'all? The United States.
United States.
Yeah, so you can never furnish no copy of my indebtedness that's fraudulent. If the consumer so requests, and if the different billing error occurs, correct the billing error and credit the consumer account with any disputed amount related to a finance or other charges. See, it's finance, meaning the government is the finance or other charges as applicable. It says creditors, if you paying the finance, that means that you're paying the amount you're supposed to be receiving. Finance means somebody's supposed to be paying for you. All right. A creditor's right and duties after resolution: if the creditor, after complying with all of the requirements of this section, determines that the consumer owes all or part of the disputed amount, related finance, or other charges, the creditor shall promptly notify in writing within the time payment is due in a portion of the disputed amount and related finance or other charges that the consumer still owes, right, shall allow time as applicable during which the consumer can pay the amount under this paragraph, right? Now, then it says may report, not saying that they may report, or an account or an amount has delinquent because the amount due still remains, has allowed time and a period applicable for you to dispute it, right? Then it says it may not report an amount on the account is delinquent because the amount due under paragraph 1 section remains unpaid. If the creditor receives within the time allowed for payment in paragraph G3 of this section for the written notice from the consumer that any portion of the billing error still remains in dispute, unless the creditor also promptly reports that the amount or the account is in dispute, mails or delivers to the consumer at the same time the dispute is made a written notice of the name and the address of each person who the creditor makes the report, and promptly reports any subsequent resolution reported delinquency to all persons. A creditor that has fully complied with the requirements of this section has no further responsibilities. And if a consumer reasserts substantially the same billing error, then it says a creditor shall comply with the requirements of Regulation E as applicable governing error resolution. So basically, you know, they can come out and say that no billing error took place, but you can still say that you still dispute it, even, you know, I still continue this dispute. And so when they report it to your credit, they got to report it as a disputed debt being reported or something to that degree. But at the same time, it's an obligation of the United States, and you can use that same title to dispute anything on your credit report too, because they reporting inaccuracies. That's inaccurate according to this is documentary evidence of a United States obligation. And I dispute that I owe any amount, as this document does not identify me as a debtor. I am the payee stated in this document, entitled to receive a payment of a United States obligation. You're misrepresenting the nature of this document. Does that make sense?
Right. Yeah.
Yeah, 100%. Because all of this is about the
Right.
whole web is misrepresentation, getting you
Yes,
to
sir.
believe and getting you to believe it.
Right. They're getting you believe that you are the debtor when actually the true debtor uh
It's
is
It's
the
them.
them. Yeah.
exactly identifying transaction on a periodic statement. I'm trying to, I think this is where it's at.
What you was looking for earlier?
Yeah, I'm trying to find it. It's in here somewhere where transaction including debited the transaction, no sale credit for each transaction involving the seller property. So all this right here is
And that joint telling you how to read your whole statement. That's literally it right there.
yeah. And I'll be explaining to you how the statement works. I'm trying to find where it talks about whenever a account is outstanding and the amount is due to the United States, the creditor, it tells you how the creditors they how basically how they supposed to create the statement. It tell them what all they got to put on it, the due date, late payment, acceptance prior to second equivalent form required, credit card account, the due date for payment, the each billing cycle, the amount of the late payment increase. It's in here, it's in this section somewhere. I don't know if it's this section specifically, but it's in here where it talks about that's how I know that before I even knew about Title 31, uh section 15,
Mm-hmm.
I had read it in here where it talked about the statements and how that anytime they identify an obligation that is due to the United States on any account, they must issue a statement to the owner of the account specifying the amounts, how much is due, any kind of whatever, and then they must deliver it to you. You know what I'm saying? And then you supposed to make the payment, and the payment is supposed to be charged to the United States. So that's why I say you can issue it to the IRS, you can issue it to anybody against the United States. But I can't find it, but I'm gonna leave it right here. Y'all got any more questions for me before I get ready to dissipate from off of this screen?
Nah, that was a pretty clear cut, detailed instructional video, in my opinion.
Yeah, I feel like you don't really get that. You just need to study some more, honestly. It's pretty straightforward. It's read it straight from the book.
I mean, yeah, I mean, if you can't, if you don't understand what's going on, right by now, you know what I'm saying? I guess you ain't gonna never figure it out, but I just pretty much showed it to you that these are United States debts. It backs up everything with law. Remember, and according to the law, it says that the gold that real money is gold and silver. So if we're not using it gold and silver, then we're using fiat currency. And fiat currency is money issued by the government, and the government gives full faith and credit to all fiat currency. So if you're using fiat currency, if there's an account open and established by fiat currency or anything,
Right.
that's a United States obligation.
And now we're all dealing with credits.
Facts. And everything is dealing with credit. So if you got a bank account, if you got anything, you need to assign it to the United States for all the unpaid balances due and payable. Anything under that account, you assign it to the Treasury. You make the Treasury your fiduciary, that the Treasury shall be responsible for any payments and anything that you shall have the rights to use the account.
Right.
See
And
what I'm
crystal, bro.
saying?
Crystal clear, bro.
And you assign all the indebtedness to the United States. It makes sense?
Yes,
Yeah,
sir.
crystal.
All right, child. Well, it was a pleasure, man. I thank y'all for, being on this class with me, man, and participating. I just want to say, man, y'all keep doing what y'all doing, keep studying, keep, reading as much as you possibly can, learn as much as you possibly can. I know it's a lot of information, but the more and more you start reading it, you're gonna realize that it's repetitious, that it's a lot of the same information just being said in many different ways. And the more you start really reading it and tapping into it, you're gonna realize, man, I realize this is really just the exact same stuff, just being said in different ways. But just keep doing what you're doing, and eventually you're gonna prevail, man. Y'all really a lot further ahead in this commercial venue than y'all really think y'all are. Y'all know a lot more than a lot of the average people out here that studying this information based off uh y'all interactions and studying with me, because of the things that I teach you, and the way that I teach is so different and unique than any other person who's actually teaching this information. So anybody that
Correct.
come amongst me, when they leave, they're gonna have substance. If they go amongst any other person that's teaching this information, they gonna be able to tell them what they doing wrong. They're gonna be like, nah, that ain't
Yeah.
right, bro.
You ain't
No,
Nah,
for
nah,
lying,
real.
bro.
nah. They're gonna
For
be like, let
real.
me take you over here and show you. See this over here,
Yeah.
I have to show you, because they
Facts.
actually got I make sure that my students have the basic fundamental foundation of what's really taking place.
Correct.
You
So
ain't
you
lying,
know
bro.
what you're actually supposed to be doing. All
Yeah.
right.
You
And
can
with
do.
that said, man, I'm gonna let it, I'm gonna lead like I always do in love, truth, peace, freedom, justice, and equality for us all. Y'all got anything y'all want to say before I crash out?
Nah, bro. Appreciate the opportunity though.
Yeah, for sure. And always, it's a blessing, what I'm saying, to help us and just expand our knowledge, brother.
Okay. All right. Well, like I said, any inspiration for anybody that may see the video, who may not be certain of whether or not they should join, be a member, may feel like they might be wasting their money or wasting their time if they came in. It might be a lot of stuff they already think they know. Any kind of words to a person who may be undecided about whether or not they should become a member of Building Better Minds.
I'll say this. If you know a little bit about this information, and some people don't even believe that this is real, but the one thing about Brother Isaiah, he take you to where you can see it with your own eyes. This ain't do this, do that, do that. He actually showing you where to read it. So once you get your own understanding, then you realize that, yo, now this is where it's at. And it's a lot of people teaching this stuff. Everybody got their own way of teaching, but he thorough. You know what I'm saying? And once you get it, and it is hard work. Don't get it twisted, bro. It's hard work. But if you dedicated and you want to change your life for the better, and see the different way of living other than out here working hard, like some of us are still doing, you know what I'm saying? And really breaking your back for pennies on the dollar that's already owed to you. then I suggest that you go on and tap in with Brother Isaiah and building better minds, bro. Because I didn't know. I knew very little when I came in. This is a personal testimony. I knew very little, bro. I done grew so much just in the year of studying, reading. You know what I'm saying? Conversations like this Zoom. You know what I'm saying? He teach like this every class. You know what I'm saying? He gonna drive the point home, so you can't miss out on what he's saying because after a while it get redundant. You be like, oh shit, I know that for myself. You know what I'm saying? So I suggest that if you're hearing this video, you watching it, and you on the fence, go on dive in, man. You know, 10 toes.
For
That's all I
sure.
And
gotta say.
I got one thing as well too. I want people to understand, like, of course, brother Isaiah, y'all gotta remember brother Isaiah tells you in every video, it's not it's not for the swift, what I'm saying? It's those who stay in it for the long haul.
Yeah,
Those who are younger, I mean, I'm younger too, but we have those impatient tendencies, but you just gotta in those moments you feel impatient, you want it now. You can't get the big stuff unless you get your foundation, your fundamentals sound and really grounded. Brother Isaiah, the way he teach, might make people upset because he don't do it for you.
correct.
He make you use your brain, which God gave you. You know what I'm saying? So he brings you to the intellect that you've already been given. So it's imperative for you to use that, for you to understand and equip yourself this knowledge. And the way Brother Isaiah teach you is he teaching you how to fish for yourself. He not giving you tool. He giving you everything you need. That way it's really up to you. And I just would let those who are on the fence you just got to understand that, man. It's for your benefit. So he don't have to be doing none of this. So just
Correct.
understanding that a brother like this who's dedicated to getting the foundation is a blessing just in and of itself, and him willing to share that with you, man, it ain't even about the money. You're gonna have to, nothing is free. You know what I'm saying? It's gonna cost you something, and it may not be of monetary value, but you also never know what you're gonna get from it. Just being in this mentorship, I've made great relationships, man. Like just the fact that I can even speak with Brother Isaiah in a closed setting like this is a blessing, but that only testaments to just staying in and with it. You know what I'm saying? Made great relationships that are last forever. So it's an investment, just like with everything else in this life that you want to get out of something. It's all about what you put into it to get the outcome. So just dive in, man. And if all the time you're gonna be using farting around trying to figure this stuff out on your own, man, you might as well just expedite it and be in the right spot. So
Absolutely.
build your mind with building better
You straight
minds.
up.
Say that then.
Yes,
Build
sir.
your mind with building better minds. Absolutely. Well, I thank both of you brothers, man, for not just for being members, but for being active members that's actually, applying yourself, learning, being involved in the classes. It's one thing to be a student, but it's another thing to be an active student. We have a lot of, it's one thing to have a lot of students, but if they're not actively participating or performing, then it can get to the point to where you get stagnated, and that's one thing I don't want people to do. I want you to learn, but at the same time, I want you to act on what you know. You know what I'm saying? So reading and studying before you act, my ears, it's like if I say, uh, we're going over the Power of Attorney Act, and then you go create a power of attorney without actually really studying, and then you try to file it with your bank, and then you say, man, they ain't accept my power of attorney. And I say, hey, what you do? Well, I put my name, and then I put my surname and give it name, then I put my legal name as then I gotta tell you, that's a sole proprietorship. They gonna say,
Facts,
you see what I'm saying?
Correct.
facts,
So you see what
facts.
I'm saying? But it take for you to
Mm-hmm.
go through these mistakes
Mm-hmm.
for you to learn. I did all the exact same thing, naming all caps and lower uppercase. Man, that's a sole
For real.
proprietorship, man.
Facts,
Now, when you think about it, you be like, dang.
I'm tripping.
God,
facts. You know
you
what
know
I'm
what I'm
saying?
saying? You know how many people was teaching that got so many of us wanting to see that way as the rightful way to do it, because when you read the redemption manual, all of it is set up like that. or they got your name in all caps, and then they got your living name as a separate name, even though that may be true, still considered as a sole proprietor.
Yes, sir.
And that's how they getting over on us when we trying to separate ourselves from a sole proprietorship that we're actually tied to.
Big facts, bro. And understanding how to operate in that capacity as well. You got, man, they just don't know, bro.
Yeah, they better tap in.
You gotta tap in, bro. Hey, if you
For
don't tap
real.
in, man, you're not like brother Isaiah say all the time, bro. This that don't mean nothing unless you applying it. Knowledge don't mean nothing unless you're applying it. So
Yeah.
you really just there to acquire that skill set alone. I need to learn the knowledge so that I can learn and better sharpen my skill set of applying, my skill set of applying any knowledge I receive and discerning it. That's really all that you want, bro. So just y'all just better
Right.
tap in and just learn, bro. Learn how to apply knowledge, learn how to get
Yeah.
knowledge, learn how to receive it, ingest it, and then use it.
Exactly. Exactly. But so with that said, man, we're gonna get on up out of here, man. And thank everybody for tuning in who watched this video. Make sure that that if you wanna, I got a lot of great things on the website. I got step-by-step courses, I got mentorships, I got a lot of different things on there that can benefit you and your family. If you're the type of person and you like more structure, you want to go through a structure of learning step by step, I got a lot of that on there for you too, to documents, forms, explaining to you with the laws, everything for you so that you can get the best benefits, because I know everybody learns a little bit different than others. You know, some people learn like how we did today, and some people, they need more structure. They need something like a classroom setting where they reading. And so, you know, I put different formats together for different types of individuals that like different types of structures and learning. Because I know some people, they don't like to be in an open venue. They like to be in a classroom setting where they doing their own work. You see what I'm saying? So I get it, and I'm trying to accommodate everybody. So I ask that y'all be patient. A lot of this stuff takes time, like the same things we learning about them, or a lot of the same things that we learn in the institute for ourselves, because a lot of the same things that they do, when we trying to take flight and do business, then we have to mimic a lot of the same things because we're following in that same path if we doing business. So with that said, I'm out of here, man. Peace and love. Thanks for tuning
Peace.
in. Catch y'all in the next one.
Peace out, brother.
Peace.
Be blessed.